didn't walk into my life, he backed into it, reversing a black Porsche Cayenne into the parking space next to mine outside the hospital where I worked, then stepping out in a suit that cost more than my monthly rent, checking his phone before he even looked up. I was a pediatric nurse. I had just finished a 12-hour shift. I had dried applesauce on my scrubs and a granola bar in my pocket that I'd been saving since 7 in the morning. He looked at me the way people look at a street sign, briefly, functionally, and then away. I don't know why I smiled. I do that. My mother always said my face has no poker ability whatsoever. He smiled back. That was the beginning of everything. His name was Stephen. He was 51, divorced once, no children. He worked in private equity, the kind of work where you explain what you do, and everyone nods like they understand, and nobody does. He was charming in that quiet, considered way that takes years to develop. Not loud, not showy. He asked questions and actually listened to the answers. He remembered things. 3 weeks after we met, he brought up something I'd mentioned in passing about my younger sister's college major. He'd held on to it. I was 29. I had dated exactly 2 serious people before him, neither of whom I'd introduced to anyone now. I was careful. I thought I was careful. We dated for 7 months before I found out I was pregnant. I sat in my car in the hospital parking garage, same parking garage, different spot, and held the test in both hands like it might change its mind. 2 lines. Very clear. No squinting required. I was not panicking. That surprised me. I was doing the mental math the way I do everything, practically, sequentially. I'm a nurse. I think in steps. Step 1, confirm. Step 2, tell him. Step 3, figure out the rest together. I called him that evening. He came over. I made tea because I didn't know what else to do with my hands. I told him. He set down the mug. He looked at the table for a long moment. Then he said, "How certain are you?" I held up the test. I'd taken 3. He nodded slowly. Then he said, "I need some time to think." I said, "Of course." He left before the tea finished steeping. He called 2 days later. He was calm. That deliberate calm that I would come to understand was not peace, but control. He said he'd been thinking. He said this was not something he had planned for, not at this point in his life. He said he cared about me. He wanted to be clear about that, but he didn't think he was in a position, emotionally, logistically, to become a father right now. I said, right now, or ever. He was quiet for a moment. Then he said, "I don't know." I said, "I'm keeping it." Another pause. Then, "I understand. We should talk more about what that means." We didn't talk more about what that means. We didn't talk more. Not for 3 weeks. His texts became shorter. His calls became fewer. By week 4, I was the one always initiating contact, and his responses were cordial and brief, like a coworker you liked well enough but didn't really know. I was 11 weeks along when I found out at my first ultrasound that there were 2. Twin boys. The technician was excited. She pointed at the screen, tracing shapes I could barely make out, explaining the positioning, talking about what to expect going forward. I was nodding, but half my brain was already somewhere else, already rehearsing the conversation I had not yet had. I drove home. I sat in my kitchen for a long time. Then I picked up my phone and called him. He didn't answer. I left a voicemail. I said, "It's twins, 2 boys. Please call me back." He texted me 6 hours later. Received. "I'll be in touch. I'll be in touch. I'll be in touch." Like I was a vendor. Like I was a scheduling conflict. He was in touch 4 days later, but not the way I expected. A car pulled up outside my apartment building. A car I didn't recognize. A driver I'd never seen. The driver came to my door and handed me an envelope with my name on it in a font so clean and formal it looked like a legal document. It was not a legal document. It was a letter. 4 paragraphs, single-spaced, on heavy cream paper that cost more per sheet than my grocery budget for the day. The summary was this. His family, meaning his father, had become aware of the situation. His father was a very private man. His father ran a company with significant public-facing interests. The family's position was that the current circumstances created exposure they were not prepared to manage. They were prepared to offer a settlement, a single, lump sum payment in exchange for a signed agreement that would allow all parties to move forward with their lives separately and without ongoing obligation. The number at the bottom of the letter was $3.2 million. I read it twice. I set it down. I picked it up and read it a third time to make sure I hadn't misunderstood. I hadn't. I put it in a kitchen drawer under a takeout menu and an expired coupon, and I went to bed. I didn't sleep, but I went to bed. I want to bed. I want to be honest about something. For about 48 hours, I thought about it. I was a nurse making $64,000 a year before taxes. I had $18,000 in student loans still outstanding. I was pregnant with twins, alone, in a one-bedroom apartment on the third floor of a building with no elevator and a laundry room 2 blocks away. I was not naive about what that road looked like without any support. $3.2 million was not abstract. I could do the math. I could see the version of that life. Paid off, stable, independent. I could build something. I could take care of them, both of them, without ever needing anything from a man who had already demonstrated exactly who he was going to be. So yes, I thought about it. And then I thought about what I was actually being asked to do. I was being asked to sign a document saying my children's father had no legal relationship to them, that his name would never appear anywhere, that they would grow up without the legal right to know where half of themselves came from, that in exchange for money, I would agree that the 3 of us, me, and 2 boys who didn't exist yet outside my body, would simply disappear from his family's record. I thought about that for a long time. Then I called a family law attorney. Her name was Ms. Alderton. Not mine to borrow fully here, but she was the kind of woman who kept a box of tissues on her desk and never once apologized for knowing more than you did. She was direct. She had been doing family law in this state for 19 years. She did not flinch at the letter. She read it carefully. She set it down. She said, "They sent this before any legal proceeding?" I said yes. She said, "Good. That tells me quite a bit about where they think they stand." She walked me through the framework. In our state, child support for high-income earners is not capped the way it is in some states. The court considers the actual standard of living the children would have had if the family had remained intact. She explained what that could mean in practical terms given what I told her about his income and assets. She said, "You understand that pursuing this means litigation, likely contested, likely prolonged." I said yes. She said, "And you understand that a signed agreement, if you had signed it, would have been very difficult to undo." I said, "That's why I didn't sign it." She nodded once. She said, "Let's talk about prenatal DNA testing." I had not known, before that appointment, that prenatal paternity testing existed in the way it does now, non-invasive. A blood draw from me, a sample from him, if he agreed, and results within a few weeks. If he didn't agree, we could establish paternity after birth and file the support case from there. Either way, we were building a record. She filed the initial petition within the week. I imagine the morning his attorney called him. I imagine what that conversation sounded like on his end. Hearing a case number read aloud, hearing that there was already a filed petition in the family court system, hearing that the letter his father had authorized was now part of the record as evidence of attempted settlement prior to any legal obligation being established. I imagine he put the phone down and sat very still for a moment. I know, because his attorney called my attorney 2 hours later, that he agreed to voluntary paternity testing. The results came back on a Tuesday. I was at work. Ms. Alderton texted me, confirmed. We proceed. I went back to checking vitals and updating charts. I had 2 more hours left in my shift. The negotiation phase was what I had expected and also nothing like I had expected. His team came back with a counter-proposal. They were not contesting paternity. They were proposing a private agreement outside the court system. A structured payment, ongoing, not a lump sum, but contingent on my signing a confidentiality clause and a clause limiting any public association between him and the children. My attorney said, "They want ongoing support but with gag conditions." I said, "No." She said, "Just to confirm, no to the confidentiality clause or no to the whole package." I said, No to anything that requires my children to be a secret. She nodded. She said, "Understood." She filed for a hearing. The hearing was in the spring. I was 7 months pregnant by then. I wore a navy dress because it was the most professional thing I owned that still fit. I sat at a table with my attorney and I looked straight ahead. He came in with 2 attorneys and a man I didn't recognize who I later learned was a crisis communications consultant. A crisis communications consultant at a family court hearing about child support. That told me everything about what this situation meant to his family. Not a moral question, not a human question, but a reputation management exercise. The judge was a woman in her 60s who had clearly seen every version of this story. She was not impressed by the communications consultant. She was not impressed by the number of attorneys on the other side. She asked her questions in a flat, even voice and wrote things down and moved on. The proceedings took 2 days. I will not walk through every detail. What I will tell you is what the judge said at the conclusion. The children were entitled to a standard of living consistent with their father's actual income and assets. The confidentiality clause conditions that had been proposed were not enforceable in this jurisdiction when applied to minor children's legal identity. The support figure she named was not what his team had proposed. It was significantly higher. I heard one of his attorneys exhale sharply. It was the kind of exhale that people try to suppress but can't quite. I looked at my hands on the table and I kept my face very still. My attorney leaned over and said quietly, "That's the right number." My sons were born 6 weeks later. I will not use their real names here. I'll call them by the nicknames I gave them in the hospital, the big one and the loud one, which are self-explanatory. The big one came first, just before 3 in the morning, screaming immediately and with great commitment. The loud one followed 11 minutes later, quieter at first and then making up for it. I was alone in that delivery room except for the medical team. My mother was in the waiting room. My sister had driven 4 hours to be there. But in that specific room, in that specific room, in that specific room, in that specific moment, it was just me. I had planned for it. I had told myself I was fine with it, and I was, mostly. But there was a moment right after they placed the first one on my chest. This warm, furious, brand new person who had no idea what kind of world he'd come into. When I felt something I can only describe as the specific grief of doing something enormous and having no one next to you to hand the weight to, even briefly. I let myself feel that for about 30 seconds. Then I looked at him, and then I looked at his brother, and the math shifted completely. He petitioned for visitation 8 months later. I will not pretend that didn't catch me off guard. His attorney sent the paperwork to my attorney on a Wednesday morning, and I found out on my lunch break, sitting in a hospital break room with a sandwich I didn't finish. I called Ms. Alderton. She was calm. She said, "This is not unusual. He now has legal paternity established. He has the right to petition. That doesn't mean the court will grant unsupervised visitation immediately." She was right. The court ordered a parenting evaluation. First, a third-party assessment of both parents, living situations, stability, support systems. The evaluator was a psychologist who came to my apartment twice, observed me with the boys, reviewed my work history and references, and wrote a report that I was not allowed to read in full until the hearing. I was nervous about that report in a way I had not been nervous about anything else in this process. The legal system I understood. Or at least, I had Ms. Alderton to understand it for me. But a stranger assessing whether I was a good mother felt personal in a way that courtrooms don't. The report was fine, better than fine. The evaluator noted that the children were thriving, that the home environment was consistent and nurturing, and that the primary parent had demonstrated, in her words, remarkable stability under conditions of sustained stress. I read that phrase 3 times. He was granted supervised visitation, 2 hours, twice monthly, in a neutral location with a coordinator present, not what his team had asked for. Not unsupervised, not overnights, not holidays, not yet. His crisis communications consultant was not at that hearing. I noticed. I want to tell you about the day he met them for the first time because it is not the story you might expect. I brought the boys to the family services office, the neutral location. And I sat in a waiting room with my mother while the coordinator took them in. I had not slept well the night before. I had dressed them carefully in the morning, which was irrational, but I did it anyway. The session was 2 hours. When they brought them back out, the big one was carrying a small stuffed animal, a frog, that hadn't come in with us. The loud one had a graham cracker in each hand. I looked at them. I checked them over the way I always do. The nurse instinct, the visual scan. They were fine. They were completely fine. The coordinator told me the session had gone well. She said he had been gentle, engaged, patient. I said, good. I buckled them into their car seats. I drove to my mother's house. I sat at her kitchen table and she made me coffee and didn't say anything for a while. Then she said, "How are you doing?" I thought about it honestly. I said, "I don't know yet." She nodded. She poured the coffee. That was enough. Here is what I have learned, and I say it not as a lesson I plan to teach, but as the thing I kept running into, over and over. Every time I thought the ground had finally settled under me, money offered at the beginning of a situation tells you exactly what the person offering it believes about you. It tells you what they think you need, what they think you're afraid of, and most importantly, what they think your silence is worth. $3.2 million is a very specific number. It was calculated by someone, in a room, using some set of assumptions about who I was and what I would accept and how much I could be counted on to think short term. It was not an act of generosity. It was a transaction that required my participation to work, and the moment I didn't participate, the whole framework collapsed, because it had never been built for two people. It had been built for one person to win and one person to disappear. I did not disappear. That is, in the end, the only part of this story that I am completely certain about. Everything else, the custody arrangement, the relationship the boys will eventually have with their father, what any of this looks like in 5 years or 10. I genuinely don't know. I hold those questions with more honesty than I hold most things. But I didn't sign. I didn't disappear. I showed up to the hearings. I answered the evaluator's questions. I dressed my boys carefully on a Tuesday morning for a meeting I had complicated feelings about, and I sat in a waiting room and let the process do what the process does. They are 2 years old now. They are, genuinely, the loudest human beings I have ever encountered, which is saying something given my profession. The big one has started asking why about everything. Why is the sky? Why is the dog? Why is this? With a thoroughness that suggests he is going to be a significant problem for every teacher he ever has, and I could not be more proud. The loud one learned to climb out of his crib 2 months ago. We have not solved this problem. We are coexisting with it. My apartment still has no elevator. The laundry room is still 2 blocks away. I still have $11,000 left on my student loans. But I know what my children are owed. I know what I refuse to trade away. And on most days, not all days, but most, that is enough to feel like solid ground. If you've been where I was, standing in a kitchen with a letter you didn't ask for, doing math you shouldn't have to do, trying to figure out how much of yourself you're willing to negotiate away, I want you to know one thing before anything else. The letter is designed to make you feel like the decision has already been made. It hasn't. The decision is still yours. It was always yours. Find someone like Miss Arthy, Alderton. Ask every question you have. Don't sign anything. Show up. That's it. That's all I did. I showed up over and over until the system caught up to what I already knew, that these boys belonged in the record. They belong in the world. They are not a liability to be managed. They are mine. They are his. They are theirs. And no number on cream paper was ever going to change that. I've thought a lot about what made Stephen's father send that letter, not the money part. I understand money. I'm a nurse. I understand resources and what they mean and what it costs to not have them. What I've thought about is the certainty behind it, the absolute confidence that a number on heavy cream paper would be enough. That I would look at $3.2 million and think, yes, this is the ceiling of what I'm worth and what my children are worth, and I'll take it. That certainty came from somewhere. It came from a long history of problems being solved that way. You write the check, The problem goes away, you move forward. It had probably worked before. It's the kind of thing that works right up until it doesn't. What I keep coming back to is that his family's mistake wasn't the offer itself. It was the assumption underneath it, that I hadn't thought further than next month, that I was making a short-term decision in a long-term situation. That fear would do their work for them. I was afraid. I want to be honest about that. I was a single woman, pregnant with twins, in a one-bedroom apartment with student loans and a salary that did not account for 2 car seats and 2 cribs and 2 of everything, forever. Fear was completely rational. Fear made sense. But fear is not the same as surrender. And I think the thing that changes a situation, not magically, not all at once, but structurally and permanently, is when you refuse to let fear make your decisions before your mind has a chance to catch up. I caught up. I sat in that kitchen long enough to understand what I was actually being asked to sign away. Not money, not comfort. The legal existence of my children in their father's record. That's what $3.2 million was buying. And once I saw it that way, clearly, without the fog of panic, the decision wasn't hard at all. It was just consequential. That's the thing about choices that actually matter. They don't usually feel dramatic in the moment. I didn't feel powerful sitting at Ms. Alderton's desk the first time. I felt tired and slightly underdressed and very aware that I had a 12-hour shift the next morning. But I answered her questions honestly. I told her everything, and I let her build something from the truth I gave her. That's all I did. I was honest about my situation, and I found someone who knew how to work within the system, and I showed up every single time I was supposed to. Integrity is not a feeling. It's a series of small, unglamorous decisions that accumulate into something you can stand behind later. Filing that petition was one. Showing up to the parenting evaluation was one. Driving to that family services office and sitting in a waiting room while my sons met their father for the first time. That was one too, maybe the hardest one, because it required me to set aside everything I felt about him personally and think only about what they needed. My boys are 2 years old. They don't know this story yet. One day they will. And when they do, I want them to understand not that their mother won something, but that she refused to disappear. That she thought past the fear. That she took the longer, harder road because the shorter one had conditions attached that she wasn't willing to meet. That is the only inheritance I know how to give them with certainty. Not money. Not a clean story. Just the example of someone who looked at a situation designed to make her small and stayed full-sized anyway.